Hello and welcome to ONCA 101, Conflicts of Interest for Ontario Nonprofits. My name is Benjamin Miller. I'm a lawyer who serves nonprofits and charities, and I'm of counsel with the B.I.G charity law group. Today's video will be focused on the Ontario Not-for-Profit Corporations Act rules dealing with conflicts of interest. In particular, we'll discuss what is a conflict of interest actually, who does it apply to, when should you be disclosing that you have a conflict of interest, when are you required to disclose, how disclosing actually protects you, why it's a very good idea to disclose, and finally, how you actually vote on conflict of interest once you've disclosed. So just to begin, conflicts of interest are a really complicated area of law, and this is just a general overview. If you're dealing with the situation, it may be a really good idea to get advice from competent legal counsel. Feel free to reach out to me. I've included my contact information at the end of this presentation, or you could go to charitylawgroup.ca. So let's begin. When we're talking about a conflict of interest under the Ontario's Not-for-Profit Corporations Act, we're talking specifically about directors and officers. An officer is, for example, a president, chair, secretary, or treasurer. And a director is a member of the board of directors. When these people have either a direct contract or transaction with the nonprofit that is quote-unquote material. Material just means that it's significant enough in the eyes of the law to be an issue, and it's very fact-specific, obviously. So when a director or officer is directly has a contract with the nonprofit, or they are heavily involved in the entity that has a contract with the nonprofit, then you've got a conflict of interest. Now, what does it mean to be heavily involved? At what point do you have a material interest? All these things are very fact-specific. But basically, if it smells kind of funny, right, if you kind of know that the person's own interests are at stake in their dealings with the nonprofit, you can err on the side of caution and pretty much say that's a conflict of interest. You can be intuitive about this, and worst case scenario, consult with legal counsel. So when you think you have a conflict of interest, what do? Well, the Ontario Not-for-Profit Corporations Act says you should pretty much tell your board, and do so in writing, if you're a director, at the next possible board meeting after you have the conflict of interest or find out you have the conflict of interest. If you're an officer, it's even sooner. You need to tell your board pretty much as soon as you find out that you have the conflict of interest, or as soon as you develop the conflict of interest. Once you've told your board, you don't have to keep telling them unless the facts change a whole bunch. So, disclosing is a really good idea, although it can be awkward. The reason it's a good idea is that if the contract is approved, so you tell them, yeah, I own the t-shirt company you're buying t-shirts from, and then they go ahead and they still continue buying the t-shirts from that company, and you've acted honestly and in good faith, and they're getting a decent price, it's a reasonable contract, then even though there was a conflict of interest, the contract can't be set aside, and you can't be forced to fork over your profits back to the nonprofit. However, if any of these elements are missing, if you didn't disclose, if you didn't act honestly and in good faith, or if the contract wasn't reasonable, then you could potentially be sued for the profits that you get from the contract, or the contract can be set aside. So to avoid that, it's best to be open, honest, transparent, and disclose. Now, how does it work to vote on a potential? Let's say the contract hasn't already been decided on. There's just a potential contract that a director or officer has a material interest in. How do you vote on that contract? The answer is the director cannot be at the meeting where the vote happens. It's not just that they can't be in the room for the vote. They can't even be at the meeting. And if this ruins your quorum, if let's say you just had 50% plus one directors available for a meeting, but one of them has a conflict of interest, don't worry about it. The Act says you still have quorum. So that was just dipping our toes into conflicts of interest. You probably have lots of questions. If you do, feel free to send them to me at benjamin.miller@charitylawgroup.ca, or just go to charitylawgroup.ca and we'd be happy to help you through your questions. Thanks so much for listening.